Welcome to Hull on Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag that will provide information and insights into estate planning in Canada from the offices of Hull Estate Mediation in Toronto. Here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. You're listening, and again, some of you may be watching, episode 128 of our podcast on Tuesday, September the 2nd, 2008. Hello there, Ian.
Hi, Suzana.
How are you?
Just great, thanks.
That's good.
All right, working on our theme of the will challenges and when someone's not happy about what happens in a will, and talking about the process. We're trying to keep this sort of fairly generic because we find in most jurisdictions it's relatively similar. We ended our last podcast talking about two important steps. One are discoveries and one are mediation. Today we want to talk about what those two steps are, what they mean in the process, and then secondly, talk a little bit about the strategic call as to if and when and what order you may proceed with them. So what are discoveries, Suzana?
Well, discoveries, Ian, and to distinguish that from mediation, is when you actually will go through and have lawyers in the room with the other side, with the parties, and actually asking them the questions, asking them for the story. And you're going to have a court reporter who's in the room who's going to take that evidence, it's going to transcribe it, put it into a written form, so that if and when this matter gets to trial, you've got that evidence captured in writing.
And it's the classic sort of TV show version of depositions, the term that is known best in the US. And it is a chance for both sides to really comprehensively explore the strengths and weaknesses of their other side's case. Now, why discoveries are so particularly important in will challenges is that it gets the opportunity to dive into questions of capacity. And what we find with will challenges is, our experience is that ultimately, a judge has to decide whether or not the individual had capacity. That's a judge's job. But to get at the capacity, you want to try to flush out trigger points. So, for example, if you're challenging a will, you'll want to look at the D-Day, the day the will is signed, and in discoveries, start asking questions that tie into the behavior specifically of the person who drew the will in or around that time. Talk about things like the old adage we used to say is that, you know, could he count backwards from 100? Did he know who the President of the United States was or the Prime Minister of Canada was? Those kinds of questions. Those kinds of questions, for example, come from a non-skilled individual like myself, who's a lawyer. I'm not a doctor. But they come out of what are known as many of the capacity tests that are in existence. For example, the mini mental test that is a fairly universal test that doctors would employ. So the discoveries can be cumbersome. They can be tremendously expensive. They can be tremendously important. So it is, I like the Canadian term in a way, it is what it is. We discover the case. So let's turn to the next concept that we're going to be dealing with, and that is mediation. And that's a bit of relatively new turn of events. So we've got the discoveries as a process, and then we've got mediation. And then we want to talk about what we mean by mediation and arbitration and those kinds of terms.
And what happens during a mediation process is that you will normally have a mediator who's a third-party neutral person who's going to help the parties settle their case, essentially. And so a mediator is someone who is going to just step into the process, work with the parties, work with their counsel. It's a non-binding process, and that'll distinguish it from arbitration, which is actually a binding process by which some resolution will come about. With mediation, the parties themselves decide if they're going to settle, and if so, on what terms.
All right, let's spend a couple minutes talking about what the day of mediation. We've heard about what discoveries are. It's fairly straightforward. Sit at the table with your counsel, tell your story, questions are asked of you, transcripts are taken that can be held against you in the future proceedings. Mm-hmm. What's mediation? What's the process about? What can they expect about when they step into the mediation fray and they've got a facilitator working with them?
Well, the mediation process, Ian, is very unstructured, and it's a very different environment than a trial process or a courtroom process. What will happen is typically the parties will be put at first in their own rooms with their lawyers. If everyone is willing to do so, a mediator will then start with a general opening session, bring everyone into one room together, make an introduction, lay the groundwork for the business day. We always call it a business resolution, a business day, where we put the litigation on hold and we see if we can just settle the whole matter without worrying about all of the issues that would arise otherwise during the course of a trial.
So we have that open session, and we will often see that your counsel and yourself will go into a caucus room, a separate room, where the mediator will come in, and as I say, they're facilitators. They're going to take a little bit of information from one room, a little bit of information from the other room, and see if there's a middle point that they can help facilitate, bring together a resolution. And with will challenge proceedings, mediation can be such a tremendous assistance to the process because of the fundamental fact that there is gray area in every respect of these cases. You're never going to know. And the reason why? Because the one thing you're never going to get back is the person who died. And their evidence is never going to be in front of the court in any pure fashion. So that gray area of itself has, in my view, facilitated the mediation process tremendously in the litigation process. So we know a little bit about the day or days that mediation would result in. Let's wind up our discussion here today on the strategy call. When do you go to mediation? When do you go to discoveries? And does it matter?
And that really is an important strategic call because these processes, each of these processes as you move from the very beginning to the very end, are expensive, time-consuming, and processes with really no guaranteed results at the end of the day. And many times what we will see is if the evidence that is unfolded during the course of the preliminary investigations, once the materials are coming in, the medical records, the solicitor's notes, the financial records, if the parties feel that they're in a position at that point to move forward to a meaningful mediation, then it may make more economical sense to put the discoveries on hold, go to mediation, and see if you can settle it. And then if it turns out that there is not enough of a gray zone, or if the parties aren't willing to meet somewhere between winning and losing, then you may have to step into the next phase of the litigation, which is the discoveries.
So I agree. I mean, I think it's almost always better to start with mediation. And I say that because in a will challenge environment, there's not a lot of surprises by the time you get there. And why I say that is if you've done your homework, remember what we talked about. We've got some preliminary investigation at the start, okay? So we get a sense of the case. Talk to a few witnesses, talk to our clients. Then in the course of bringing the motion for directions, what we have to do there is we're trying to canvass what extent of disclosure needs to be obtained. And in that process, you typically find out a lot about the case in any event because you're asking about who's seen what, and some people will be able to tell you little bits and so forth. And our next step in our flow chart was this intense investigation. And that's when really you've got your disclosure, you've assessed it, because you've brought in the medical records, you've talked to witnesses, you've got the lawyer's notes, you've got the three corners of the lawsuit organized. And so then the tough call comes, and that is what do you do to go to mediation? So we're going to wind up today's podcast with that sort of thought, and we're going to finish exploring that concept in our next podcast. So thank you very much, Suzana.
Thanks to you too, Ian.
You've been listening to Hull on Estate and Succession Planning with Ian Hull and Suzana Popovic-Montag. The podcast you've been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other Hull On podcasts or to leave any questions or comments, please visit our website at hullestatemediation.com.